those options to Mr. Lewis. Time served is not on the table. It's 6 years, it's a trial, or it's an open plea to me.
All right, see, I don't know what my charge is.
Well, the charge is harassment of a public servant. I'm sure Mr. Lewis has gone over
Yeah.
that with you. Mr. Rojas, will your client waive the formal reading of the indictment in each case?
She will, Your Honor.
Ms. Jordan, in cause number 25, DCCR 1401, you're charged with a state jail felony offense of unauthorized use of a vehicle from February 21st of 2025. That indictment also alleges that you were previously convicted of the state jail felony offense of possession of a controlled substance, July 26th of 2013. And after that, you were convicted of the state jail felony offense of possession of a controlled substance, November 16th of 2017. And then after that, convicted of state jail felony offense of theft, January 26th of 2022. And on that same day, also a state jail felony of possession of a controlled substance. And then after all of those were final, you were convicted of possession of a controlled substance, a state jail felony, January 5th of 2024. How do you plead to that charge?
Guilty.
And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty in that case freely and voluntarily?
Yes, ma'am.
And also your pleas of true freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they've charged you
Yes,
with?
ma'am. And Judge, at the appropriate time, I know the court will need an explanation as to why I made the offer.
Okay, good. Just a second. All right, then we have clause number 25, DCCR 1403. And in that case, you are charged with a state jail felony offense of theft of property with previous convictions from June 4th of 2025. It alleges in this indictment that you were previously convicted of theft August 7th of 2007, and then again, January 26th of 2022. It also alleges those same prior state jail felony offenses as well. And how do you plead to that charge?
Guilty.
And are those prior convictions all true?
Yes, ma'am.
And again, in this case, did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you actually have done what they've charged you with?
Yes, ma'am.
In both of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1.
Okay.
Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Explanation?
I know that the history does not dictate such an offer. I think there are some extenuating circumstances that I took into consideration. One being the underlying offenses themselves. I think her co-defendant, Brandon Lewing, who's also said before the court, is actually the more culpable party, especially in the UUMV. His case was supposed to be resolved last week, and Mr. Smith ended up withdrawing from that case. So it is still pending. Ms. Jordan has agreed to cooperate against Mr. Lewing if necessary. He actually has about twice as many priors as she does. It's also my understanding that when she discharges from TDC, and correct me if I'm wrong, that she's been accepted into a women's center type program. Invite her to try to help get her back on the right track and keep in touch with me so that if we need to use her cooperation, we can. That was my thought process when making this offer. I certainly understand if the court doesn't think it's appropriate.
No, I appreciate the explanation. Ms. Jordan, each of those cases I have here on the tablet, these documents that have your signature on them, that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Also want to make sure you understand if I go along with these agreements and you're back here on any other felony, I'm going to take it pretty personally and probably Miss Malfino will too. You're not going to get deals like this again. Do you
Yes, ma'am.
understand?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation,
Yes, ma'am.
exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number one in each case.
Objection.
It's admitted in each case. Is there any evidence that Ms. Jordan is not competent?
No, Your Honor.
All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of guilty and true freely and voluntarily. In cause number 25, DCCR 1401, find sufficient evidence to find you guilty. At this time, find you guilty of unauthorized use of a vehicle. Find those prior felony convictions true. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Thank you.
Cause number 25, DCCR 1403, also find that you entered your plea of guilty and true freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm handing you the trial court certifications in each of your cases that shows these were agreements that I followed, so you waived your right to appeal.
Yes, ma'am.
I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
Yes, ma'am.
Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas, excuse me. All right, thank you, ma'am. You go back with the bailiff.
Thank you. Thank you so much. Thank you.
Hurd Junior,
I didn't hear you.
are you Perry
Yeah,
Hurd
right.
Junior?
That's correct.
Okay, and this is cause number 26, DCCR 0052. Mr. Hurd is charged with harassment of a public servant. Mr. Lewis?
Judge, since we've gotten the report back on the competency issue, I've gotten an offer from the state. And I gave that to Mr. Hurd. And of course, he had been adamant in requesting a time served offer. I talked to Mr. Smith about it. I really want to bring him out so he can understand that denial of his offer is coming from him. It's not me.
So Mr. Hurd, Mr. Lewis can do the best he can to negotiate with the district attorney's office. And so it sounds like he's gotten an offer. Mr. Smith, is there any reason to believe that offer would change?
No, Judge. Mr. Hurd is asking for time served. There is no way I would consider time served in this case. I came down from 10 to 6. That is the lowest that I will go in this case.
So the offer is what the offer is. So what your choice is at this point is to either take that offer or to go to trial and let a jury decide two things. One, if you're guilty or not. And then if they find you guilty, you can leave your punishment up to that jury. The third option would be to plea open to the court as well. So you have about 3 options. You can talk about those options to Mr. Lewis. Time served is not on the table. It's 6 years. It's a trial, or it's an open plea to me.
All right, see, I don't know what the charge is.
Well, the charge is harassment of a public servant. I'm sure Mr. Lewis has gone over
Yeah.
that with you. Well,
Work.
here's the thing. The offer is what the offer is.
All right,
If
so
you talk to, what I'm going to do is reset your case for maybe 2 weeks, Mr. Lewis, you can go visit. Mr. Lewis is going to come out to the jail and go over all that with you again.
when,
But listen, hold on, don't talk over me. It's real important, okay? So when he comes out to talk to you, it's important that you don't focus on some other deal. He's going to come out to you with the best deal that he can get from the district attorney's office, and you'll just have a decision to make after talking to him, and we'll get what that decision is in 2 weeks, okay?
all right.
All right, he'll bring the discovery,
Like,
he'll go over what,
6 years is on there, it'll be out here.
say it again,
So if the 6 years is out here, it will be out here.
out here where? I don't understand your question.
You guys sentenced the 6 years on
If you get 6 years, then what?
It'll be in Beaumont.
I have no idea. So what happens if you go to TDC? Typically is everyone that goes to TDC goes first to Huntsville, and that's where you get classified as to where you should go.
I'm gonna talk.
Hang on, let me tell you, there's more about that though, because typically they try to get you back in the area where you are so that you can have visits and stuff like that. But I don't have any say so over that. That would be, look at me, pay attention. So I don't have any say so over that. That would be up to the prison authorities, okay? All right, go back with the bail.
All right, good night.
At the end of the day, this hearing is a reminder that courtroom decisions come with serious consequences. Plea offers can change the direction of a case, but once the judge lays out the options, the decision ultimately falls on the defendant. What would you have done in that situation? Take the deal or risk everything at trial?